Do you want to successfully complete the D352 Objective Assessment Exam? Then you are in the right place. Our website provides a list of questions and answers for your success in the D352 OA Exam for free. We understand that acing your OA exam can be quite challenging. That's why we provide completely free exam guides and practice questions for you. In this video, we will cover questions from workplace discrimination, employment law, protected classes, legal concepts, and safety and compensation. So, let's get started. 1. Which of the following employees is most likely protected by the Family Medical Leave Act? A. An employee needing time off for a minor cold. B. An employee requiring time to care for a sick child with a serious health condition. C. An employee requesting time off to attend a wedding. D. An employee looking to take vacation time. What do you think is the answer? Correct answer, B. An employee requiring time to care for a sick child with a serious health condition. Explanation. Option B is correct because the Family and Medical Leave Act is a US law that helps employees take time off work for important family or medical reasons without losing their job. One of the main reasons FMLA covers is needing to care for a child, spouse, or parent who has a serious health condition. Option A is incorrect because a minor cold is usually not serious enough for FMLA coverage. Option C is incorrect because attending a wedding is not a qualifying event under FMLA. Option D is incorrect because taking vacation time is not a qualifying event under FMLA. 2. Which law requires federal contractors to take affirmative action in hiring individuals with disabilities? A. Americans with Disabilities Act. B. Civil Rights Act of 1964. C. Rehabilitation Act of 1973. D. Worker Adjustment and Retraining Notification Act. Can you guess the answer? Correct answer, C. Rehabilitation Act of 1973. Explanation. Option C is correct because the Rehabilitation Act of 1973 requires federal contractors to take affirmative action to hire individuals with disabilities. Option A is incorrect because the Americans with Disabilities Act prohibits discrimination but doesn't focus on affirmative action for federal contractors. Option B is incorrect because the Civil Rights Act of 1964 prohibits discrimination based on race, colour, religion, sex, or national origin, not disability. Option D is incorrect because the Worker Adjustment and Retraining Notification Act concerns plant closings and layoffs, not disability hiring. 3. A company requires that all employees speak only English in the workplace, including during break times. This practice violates which law? A. Title VII of the Civil Rights Act of 1964. B. Occupational Safety and Health Act. C. Family Medical Leave Act. D. Americans with Disabilities Act. Can you guess the answer? Correct answer, A. Title VII of the Civil Rights Act of 1964. Explanation. Option A is correct because Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on national origin. The Equal Employment Opportunity Commission, which enforces Title VII, says that English-only rules in the workplace can sometimes be a form of national origin discrimination if they are applied at all times and are not truly necessary for the safe or efficient operation of the business. Option B is incorrect because the Occupational Safety and Health Act is about workplace safety, not language requirements. Option C is incorrect because the Family Medical Leave Act is about family and medical leave, not language requirements. Option D is incorrect because the Americans with Disabilities Act is about disability discrimination, not language requirements. Four. Which of the following is an example of a legal affirmative action programme? A. Adjusting performance evaluations based on race. B. Recruiting from colleges with high minority enrolment. C. Promoting minority employees regardless of qualifications. D. Refusing to hire employees from non-minority backgrounds. Do you know the answer? Correct answer, B. Recruiting from colleges with high minority enrolment. Explanation. Option B is correct because affirmative action programs are designed to help ensure equal employment opportunities for groups of people who may have faced discrimination in the past. A legal way to do this is by making special efforts to reach out and recruit qualified candidates from diverse backgrounds, such as by advertising jobs at colleges that have a lot of minority students. This helps create a diverse pool of applicants without discriminating. Option A is incorrect because adjusting performance evaluations based on race is a form of illegal discrimination. Option C is incorrect because promoting minority employees regardless of qualifications is also a form of illegal discrimination or reverse discrimination. Option D is incorrect because refusing to hire employees from non-minority backgrounds constitutes illegal reverse discrimination. 5. An employer fails to provide reasonable accommodations for an employee with a known disability. Which law has the employer violated? A. Occupational Safety and Health Act. B. Americans with Disabilities Act. C. Fair Labor Standards Act. D. Title VII of the Civil Rights Act of 1964. Can you guess the answer? Correct answer, B. Americans with Disabilities Act. Explanation. Option B is correct because the Americans with Disabilities Act prohibits discrimination against qualified individuals with disabilities and requires employers to provide reasonable accommodations unless it would cause undue hardship. Option A is incorrect because the Occupational Safety and Health Act focuses on ensuring workplace safety standards. Option C is incorrect because the Fair Labor Standards Act deals with minimum wage, overtime pay, and child labour laws. Option D is incorrect because Title VII of the Civil Rights Act of 1964 prohibits discrimination based on race, colour, religion, sex, or national origin. Six. Which law protects employees over the age of 40 from workplace discrimination? A. Title VII of the Civil Rights Act. B. Age Discrimination in Employment Act. C. Family Medical Leave Act. D. Americans with Disabilities Act. What do you think is the answer? Correct answer, B. Age Discrimination in Employment Act. Explanation. Option B is correct because the Age Discrimination in Employment Act is a US federal law that specifically protects workers who are 40 years old or older from being treated unfairly in employment decisions just because of their age. Option A is incorrect because Title VII protects against discrimination based on race, colour, religion, sex or national origin, not age. Option C is incorrect because the Family Medical Leave Act is about family and medical leave, not age discrimination. Option D is incorrect because the Americans with Disabilities Act is about disability discrimination, not age discrimination. 7. A company is required to provide 60 days' notice before a mass layoff. Which law imposes this requirement? A. Fair Labor Standards Act. B. Worker Adjustment and Retraining Notification Act. C. Family Medical Leave Act. D. National Labour Relations Act. What do you think is the answer? Correct answer, B. Worker Adjustment and Retraining Notification Act. Explanation. Option B is correct because the Worker Adjustment and Retraining Notification Act is a US law that requires many larger employers to give their employees and local government officials at least 60 days advance written notice before a big plant closing or a mass layoff. Option A is incorrect because the Fair Labor Standards Act deals with wages and hours. Option C is incorrect because the Family Medical Leave Act deals with family and medical leave. Option D is incorrect because the National Labour Relations Act deals with unions and collective bargaining. 8. An employee's request for an accommodation is denied because the employer claims it would cause undue hardship. Which law provides the framework for this determination? A. Title VII of the Civil Rights Act. B. Americans with Disabilities Act. C. Fair Labor Standards Act. D. Family Medical Leave Act. Can you guess the answer? Correct answer, B. Americans with Disabilities Act. Explanation. Option B is correct because the Americans with Disabilities Act requires employers to provide reasonable accommodations for qualified employees with disabilities. However, the ADA also says that an employer doesn't have to provide an accommodation if doing so would cause them undue hardship. Undue hardship means it would be extremely difficult or expensive for the employer to provide, considering their size, resources, and the nature of their business. The ADA provides the rules for figuring this out. Option A is incorrect because Title VII of the Civil Rights Act prohibits employment discrimination based on race, colour, religion, sex, and national origin, but does not address accommodations for disabilities. Option C is incorrect because the Fair Labor Standards Act establishes minimum wage, overtime pay, record keeping, and youth employment standards affecting full-time and part-time workers in the private sector and in federal, state, and local governments, but not disability accommodations. Option D is incorrect because the Family Medical Leave Act provides employees with job-protected, unpaid leave for qualified medical and family reasons, but does not cover disability accommodations. 9. Which of the following practices is illegal under the Immigration Reform and Control Act? A. Hiring individuals with valid work authorization. B. Verifying employee work eligibility. C. Discriminating against workers based on citizenship status. D. Conducting background checks. Can you guess the answer? Correct answer. C. Discriminating against workers based on citizenship status. Explanation. Option C is correct because the Immigration Reform and Control Act makes it illegal for employers to discriminate against job applicants or employees based on their citizenship status or national origin, as long as they are authorised to work. Option A is incorrect because hiring individuals with valid work authorization is a legal and expected practice. Option B is incorrect because verifying employee work eligibility is required by the Immigration Reform and Control Act through the I-9 form. Option D is incorrect because conducting background checks is a general hiring practice and not specifically prohibited by the Immigration Reform and Control Act, though it is subject to other laws. 10. What is the legal concept of respondit superior? A. The employer is not liable for the actions of employees. B. The employer is liable for the actions of employees conducted within the scope of employment. C. The employer must negotiate with unions. D. The employer can terminate employees at will. What do you think is the answer? Correct answer. B. The employer is liable for the actions of employees conducted within the scope of employment. Explanation. Option B is correct because respondit superior is a Latin legal term that means let the master answer. In employment law, it's a doctrine that says an employer can be held legally responsible for the wrongful or negligent actions of their employees, as long as those employees were acting within the scope of their employment when the wrongful act happened. Option A is incorrect because it states the opposite of respondit superior, which holds employers liable. Option C is incorrect because it relates to labour law and collective bargaining, not the liability of employers for employee actions. Option D is incorrect because it describes at-will employment, which is about the conditions under which an employer can terminate an employee and not related to employer liability. 11. Which of the following is an example of a hostile work environment? A. An employee receiving poor performance reviews. B. A supervisor providing constructive feedback. C. Repeated unwelcome offensive remarks about an employee's gender. D. An employee being demoted for violating company policies. Do you know the answer? Correct answer, C. Repeated unwelcome offensive remarks about an employee's gender. Explanation. Option C is correct because a hostile work environment is a form of illegal harassment that occurs when an employee is subjected to unwelcome conduct based on a protected characteristic that is so severe or happens so often that it creates an intimidating, hostile, or abusive place to work. Option A is incorrect because poor performance reviews, while unpleasant, do not create a hostile environment unless they are based on discriminatory factors. Option B is incorrect because constructive feedback is a normal part of the workplace and does not constitute a hostile environment if delivered respectfully. Option D is incorrect because being demoted for violating company policies is a legitimate employer action if done fairly and for non-discriminatory reasons, and is not related to creating a hostile environment. Which law prohibits employers from requiring employees to take a lie detector test as a condition of employment? A. Fair Labor Standards Act. B. Family Medical Leave Act. C. Employee Polygraph Protection Act. D. Occupational Safety and Health Act. Can you guess the answer? Correct answer, C. Employee Polygraph Protection Act. Explanation. Option C is correct because the Employee Polygraph Protection Act is a US federal law that generally prevents most private employers from using lie detector tests, either for pre-employment screening or as a condition of keeping a job. Option A is incorrect because the Fair Labor Standards Act establishes minimum wage, overtime pay, record keeping and child labour standards. Option B is incorrect because the Family Medical Leave Act allows employees to take unpaid leave for specified family and medical reasons. Option D is incorrect because the Occupational Safety and Health Act ensures safe and healthful working conditions for workers by setting and enforcing standards and by providing training, outreach, education, and assistance. 13. Which of the following is a violation of the Fair Labor Standards Act? A. Requiring employees to work overtime with overtime pay. B. Paying non-exempt employees less than the federal minimum wage. C. Allowing employees to work flexible schedules. D. Requiring employees to take meal breaks. What do you think is the answer? Correct answer, B. Paying non-exempt employees less than the federal minimum wage. Explanation. Option B is correct because the Fair Labor Standards Act is a US federal law that sets basic rules for how workers get paid. One of its most important rules is the establishment of a federal minimum wage, the lowest hourly rate that most employers can legally pay their non-exempt employees. Paying less than this minimum wage is a violation. Option A is incorrect because the FLSA generally requires overtime pay for overtime hours for non-exempt employees, not a violation. Option C is incorrect because allowing employees to work flexible schedules is not regulated by the FLSA. Option D is incorrect because requiring employees to take meal breaks is not directly regulated by the FLSA in most cases. (14) Which of the following employees is most likely exempt from overtime pay under the Fair Labor Standards Act? A full-time administrative employee earning USD 60,000 per year. B, a part-time hourly worker. C, a non-exempt salaried employee earning USD 40,000 per year. D, an employee earning tips. Do you know the answer? Correct answer, A, a full-time administrative employee earning USD 60,000 per year. Explanation: Option A is correct because administrative employees who perform office or non-manual work directly related to management or general business operations, whose primary duty includes the exercise of discretion and independent judgment, and who are paid a salary above a certain threshold, are exempt. Option B is incorrect because part-time hourly workers are typically non-exempt and eligible for overtime. Option C is incorrect because non-exempt salaried employees are typically eligible for overtime. Option D is incorrect because employees earning tips are also usually non-exempt, though there are special rules for tipped employees regarding minimum wage. 15. What is the purpose of the Occupational Safety and Health Act? A, to provide health insurance for employees. B, to ensure that employees receive paid leave. C, to ensure that employers provide a safe workplace free from recognised hazards. D, to regulate employee work hours. Do you know the answer? Correct answer, C, to ensure that employers provide a safe workplace free from recognised hazards. Explanation: Option C is correct because the Occupational Safety and Health Act is a US federal law that was created to ensure employers provide employees with a safe and healthy workplace, free from known dangers that could cause death or serious physical harm. Option A is incorrect because the Occupational Safety and Health Act focuses on workplace safety and health standards, not providing health insurance benefits. Option B is incorrect because the Occupational Safety and Health Act focuses on workplace safety and health standards, not paid time off. Option D is incorrect because while some aspects of work hours may indirectly relate to safety, the Fair Labor Standards Act primarily regulates work hours, not the Occupational Safety and Health Act. 16. An employee files a retaliation claim after being demoted for filing a harassment complaint. What must be shown to establish a prima facie case of retaliation? A, the employee engaged in protected activity, such as filing a complaint. B, the employer conducted a fair investigation. C, the employee received a negative performance review. D, the employer had valid reasons for the demotion. Can you guess the answer? Correct answer, A, the employee engaged in protected activity, such as filing a complaint. Explanation: Option A is correct, because to make an initial showing that an employer retaliated against them, an employee usually has to show they participated in a protected activity. The employer took some adverse employment action against them, and there's a causal link between the protected activity and the adverse action. Option B is incorrect because whether the employer conducted a fair investigation is a factor the employer might argue in their defence, but not what the employee needs to show initially. Option C is incorrect because whether the employee received a negative performance review is a factor the employer might argue in their defence, but not what the employee needs to show initially. Option D is incorrect because whether the employer had valid reasons for the demotion is a factor the employer might argue in their defence, but not what the employee needs to show initially. 17. Which law requires employers to verify an employee's eligibility to work in the United States? A. Civil Rights Act of 1964. B. Americans with Disabilities Act. C. Immigration Reform and Control Act. D. Fair Labor Standards Act. Can you guess the answer? Correct answer, C. Immigration Reform and Control Act. Explanation. Option C is correct because the Immigration Reform and Control Act of 1986 makes it illegal for employers to knowingly hire or employ individuals not authorised to work in the United States. Employers must verify the identity and employment eligibility of new hires using Form I-9 and examining documents. Option A is incorrect because the Civil Rights Act of 1964 prohibits discrimination based on race, colour, religion, sex, or national origin. Option B is incorrect because the Americans with Disabilities Act prohibits discrimination against individuals with disabilities in employment, public services and accommodations. Option D is incorrect because the Fair Labor Standards Act establishes minimum wage, overtime pay, record keeping, and child labour standards affecting full-time and part-time workers. (18) Which of the following actions could lead to a claim of gender plus discrimination? A. Refusing to hire men who have young children, but hiring women with young children. B. Hiring only female employees for specific roles. C. Offering flexible work hours to all employees. D. Implementing a mentorship program for women in the workplace. Do you know the answer? Correct answer, A. Refusing to hire men who have young children, but hiring women with young children. Explanation. Option A is correct because gender plus discrimination happens when an employer treats a subgroup of one gender differently than a subgroup of the other gender, even if they don't discriminate against all members of that gender. So refusing to hire men with young kids, while having no such rule for women with young kids, would be an example. It's discrimination based on gender plus another characteristic. Option B is incorrect because hiring only female employees for specific roles is direct gender discrimination. Option C is incorrect because offering flexible work hours to all employees is a general policy and does not inherently discriminate. Option D is incorrect because implementing a mentorship program for women in the workplace is an affirmative action type program, which can be legal if properly structured and isn't gender plus discrimination. 19. An employee reports that their supervisor spread false information about their work performance during a company meeting. Which type of tort does this describe? A. Negligence. B. Libel. C. Slander. D. Retaliation. Can you guess the answer? Correct answer, C. Slander. Explanation. Option C is correct because slander is a type of defamation, harming someone's reputation by making false statements about them. Slander specifically refers to defamation that is spoken out loud to a third party. Option A is incorrect because negligence is failing to take reasonable care to avoid causing harm to another person. Option B is incorrect because libel is defamation that is written or published, not spoken. Option D is incorrect because retaliation involves punishing someone for engaging in a protected activity, which is not described in this scenario. 20. Which of the following conditions is protected under the Americans with Disabilities Act? A. An active case of hepatitis that poses a direct threat to others. B. Temporary illness. C. Dyslexia. D. Mild seasonal allergies. Can you guess the answer? Correct answer, C. Dyslexia. Explanation. Option C is correct, because the Americans with Disabilities Act protects qualified individuals with a disability, which is defined as a physical or mental impairment that substantially limits one or more major life activities. Dyslexia is a learning disability that can substantially limit activities like reading and learning, so it is generally considered a protected disability under the ADA. Option A is incorrect because a case of hepatitis that poses a direct threat to others is not protected if it poses a direct threat that cannot be eliminated by reasonable accommodation. Option B is incorrect because a temporary illness is usually not considered a disability under the ADA. Option D is incorrect because mild seasonal allergies are usually not substantial enough to be considered a disability. 21. Which of the following situations would be considered retaliation under employment law? A. An employee receives a negative performance review after failing to meet deadlines. B. An employee is demoted after filing a discrimination complaint. C. An employee is promoted after completing a major project. D. An employee receives additional training after requesting it. Do you know the answer? Correct answer, B. An employee is demoted after filing a discrimination complaint. Explanation. Option B is correct because retaliation in employment law means an employer takes some negative action against an employee because that employee engaged in a legally protected activity. Filing a complaint about discrimination or harassment is a protected activity, so if an employee is demoted shortly after filing such a complaint, it could be seen as retaliation. Option A is incorrect because a negative performance review for failing to meet deadlines is usually a legitimate action if the review is fair and based on performance, not related to any protected activity. Option C is incorrect because being promoted after completing a major project is a positive action and not considered retaliation. Option D is incorrect because receiving additional training after requesting it is a positive action and not considered retaliation. 22. Which federal agency is responsible for enforcing anti-discrimination laws in the workplace? A. Department of Labour. B. Occupational Safety and Health Administration. C. Equal Employment Opportunity Commission. D. National Labour Relations Board. Do you know the answer? Correct answer, C. Equal Employment Opportunity Commission. Explanation. Option C is correct because the Equal Employment Opportunity Commission is the main US federal agency responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of the person's race, colour, religion, sex, national origin, age, disability, or genetic information. They investigate complaints of discrimination. Option A is incorrect because the Department of Labour enforces laws about wages, hours, and workplace safety. Option B is incorrect because the Occupational Safety and Health Administration specifically deals with workplace safety and health. Option D is incorrect because the National Labour Relations Board deals with unions and collective bargaining. 23. Which law protects employees from being fired for filing a complaint about unsafe working conditions? A. Family Medical Leave Act. B. Sarbanes-Oxley Act. C. Occupational Safety and Health Act. D. Immigration Reform and Control Act. Can you guess the answer? Correct answer. C. Occupational Safety and Health Act. Explanation. Option C is correct because the Occupational Safety and Health Act not only requires employers to provide a safe workplace, but it also has whistleblower protections. This means it's illegal for an employer to fire, demote, or otherwise retaliate against an employee because they reported a safety concern, filed a complaint with OSHA, or participated in an OSHA inspection or investigation. Option A is incorrect because the Family Medical Leave Act provides unpaid leave for specific family and medical reasons, but does not protect against retaliation for reporting unsafe conditions. Option B is incorrect because the Sarbanes-Oxley Act primarily focuses on corporate governance and financial reporting regulations for publicly traded companies, not workplace safety. Option D is incorrect because the Immigration Reform and Control Act addresses immigration and employment eligibility verification, not workplace safety or retaliation. (24) What is the primary purpose of affirmative action programs? A. To provide special treatment to minority groups. B. To promote equal employment opportunities for underrepresented groups. C. To guarantee promotions for minority employees. D. To eliminate competition in the job market. Can you guess the answer? Correct answer. B. To promote equal employment opportunities for underrepresented groups. Explanation. Option B is correct because affirmative action programs are policies and practices that employers use to try and ensure that they are providing equal opportunities in employment for groups of people who have historically been underrepresented or have faced discrimination. The goal is to create a diverse workforce and address past imbalances, not to set quotas or guarantee outcomes. Option A is incorrect because affirmative action aims to level the playing field, not to provide special treatment, which could be considered reverse discrimination. Option C is incorrect because affirmative action focuses on equal opportunity during hiring processes, not guaranteed promotions. Option D is incorrect because affirmative action seeks to foster a diverse workforce, but not by eliminating competition in the job market. 25. Under the Americans with Disabilities Act, when is an employer allowed to refuse to hire an individual with a disability? A. When the disability poses a direct threat to the health or safety of others. B. When the employee cannot work overtime. C. When the employee requires a flexible work schedule. D. When the employee requires an accommodation that is expensive. Can you guess the answer? Correct answer. A. When the disability poses a direct threat to the health or safety of others. Explanation. Option A is correct because the Americans with Disabilities Act protects qualified individuals with disabilities from discrimination. However, an employer can refuse to hire someone if their disability would pose a direct threat to the health or safety of themselves or others in the workplace, and that threat cannot be eliminated or reduced to an acceptable level by a reasonable accommodation. Option B is incorrect because an employer might be required to provide a reasonable accommodation regarding overtime if it does not cause undue hardship. Option C is incorrect because requiring a flexible work schedule might be considered a reasonable accommodation if it does not cause undue hardship. Option D is incorrect because an accommodation can be denied only if it's an undue hardship, not just because it's expensive. 26. Which law requires employers to offer continuation of healthcare coverage to employees who have been terminated? A. Family Medical Leave Act. B. Health Insurance Portability and Accountability Act. C. Consolidated Omnibus Budget Reconciliation Act. D. Fair Labor Standards Act. Do you know the answer? Correct answer, C. Consolidated Omnibus Budget Reconciliation Act. Explanation: option C is correct because the Consolidated Omnibus Budget Reconciliation Act is a US federal law that gives certain employees and their families who lose their health benefits the right to choose to continue their group health insurance coverage provided by their former employer for a limited period of time. The employee typically has to pay the full cost of the premium plus a small administrative fee. Option A is incorrect because the Family Medical Leave Act provides for unpaid leave. Option B is incorrect because the Health Insurance Portability and Accountability Act protects health information, privacy and security. Option D is incorrect because the Fair Labor Standards Act deals with wages and hours. (27) Which of the following actions is considered reverse discrimination? A. Offering promotions based on merit. B. Hiring a less qualified minority candidate over a more qualified non-minority candidate. C. Implementing diversity training programs. D. Providing equal pay to all employees regardless of gender. Can you guess the answer? Correct answer, B. Hiring a less qualified minority candidate over a more qualified non-minority candidate. Explanation: option B is correct because reverse discrimination is a term sometimes used to describe a situation where an employer is accused of discriminating against people who are in a majority group in favour of people from a minority group. Option A is incorrect because offering promotions based on merit is a legal and desirable practice. Option C is incorrect because implementing diversity training programs is generally a legal and sometimes desirable practice. Option D is incorrect because providing equal pay to all employees regardless of gender is a legal and desirable practice. 28. Which law regulates the release of private employee information to federal agencies? A. Health Insurance Portability and Accountability Act. B. Privacy Act. C. Fair Labor Standards Act. D. Equal Pay Act. Can you guess the answer? Correct answer, B. Privacy Act. Explanation: option B is correct because the Privacy Act of 1974 places restrictions on how federal government agencies can collect, use, maintain and share personally identifiable information about individuals that they have in their records. Option A is incorrect because the Health Insurance Portability and Accountability Act is primarily focused on protecting the privacy of health information, not general employee information. Option C is incorrect because the Fair Labor Standards Act deals with minimum wage, overtime pay and child labour laws, not the release of private employee information. Option D is incorrect because the Equal Pay Act focuses on ensuring equal pay for equal work, regardless of gender, and does not regulate the release of private employee information. 29. Which federal law prohibits employers from discriminating against employees based on national origin? A. Title VII of the Civil Rights Act of 1964. B. Occupational Safety and Health Act. C. Immigration Reform and Control Act. D. Fair Labor Standards Act. Can you guess the answer? Correct answer, A. Title VII of the Civil Rights Act of 1964. Explanation: option A is correct because Title VII of the Civil Rights Act of 1964 makes it illegal for employers to discriminate against job applicants or employees based on their race, colour, religion, sex or national origin. Option B is incorrect because the Occupational Safety and Health Act is about workplace safety. Option C is incorrect because the Immigration Reform and Control Act deals with hiring undocumented workers and also has anti-discrimination provisions related to citizenship/national origin, but Title VII is the primary law for national origin discrimination generally. Option D is incorrect because the Fair Labor Standards Act is about wages and hours. 30. What is the purpose of the Older Workers Benefit Protection Act? A. To allow employers to terminate older workers without cause. B. To protect the benefits of employees over the age of 40. C. To require mandatory retirement at age 65. D. To offer early retirement incentives to younger employees. Do you know the answer? Correct answer, B. To protect the benefits of employees over the age of 40. Explanation. Option B is correct because the Older Workers Benefit Protection Act is a US law that amended the Age Discrimination in Employment Act. Its main purpose is to make sure that employers do not discriminate against older workers when it comes to their employee benefits, and to set specific rules that employers must follow if they want employees to waive their rights under the ADA. Option A is incorrect because the Older Workers Benefit Protection Act actually protects older workers from being terminated without cause based on their age. Option C is incorrect because the Act prohibits mandatory retirement based on age. Option D is incorrect because the OWBPA focuses on protecting older workers' benefits and ensuring they are not discriminated against, rather than offering incentives to younger employees. 31. Which of the following is an illegal bargaining subject under labour law? A. Wages. B. Benefits. C. Working hours. D. Race quotas. What do you think is the answer? Correct answer, D. Race quotas. Explanation. Option D is correct because bargaining for race quotas, hiring or promoting based on race, is illegal as it is discriminatory and violates laws like Title VII of the Civil Rights Act. Option A is incorrect because wages are a mandatory subject of bargaining under labour law. Option B is incorrect because benefits are a mandatory subject of bargaining under labour law. Option C is incorrect because working hours are a mandatory subject of bargaining under labour law. (32) Which of the following laws regulates how consumer reporting agencies collect and disseminate credit information? A. Employee Polygraph Protection Act. B. Fair Credit Reporting Act. C. Fair Labor Standards Act. D. Occupational Safety and Health Act. What do you think is the answer? Correct answer, B. Fair Credit Reporting Act. Explanation. Option B is correct because the Fair Credit Reporting Act is a US federal law that regulates how consumer reporting agencies can collect, use, and share information about consumers in their credit reports. It also gives consumers rights like the right to see their credit report, dispute errors, and know when their credit information is used against them. Option A is incorrect because the Employee Polygraph Protection Act is about lie detector tests. Option C is incorrect because the Fair Labor Standards Act is about wages and hours. Option D is incorrect because the Occupational Safety and Health Act is about workplace safety. 33. Which of the following actions is required by employers under the Immigration Reform and Control Act? A. Verifying employees' eligibility to work in the US. B. Providing medical insurance to all employees. C. Reporting all new hires to the Department of Homeland Security. D. Hiring a specific percentage of immigrant workers. Can you guess the answer? correct answer? A. Verifying employees' eligibility to work in the US. Explanation. Option A is correct because the Immigration Reform and Control Act of 1986 is a US law that requires all employers to verify that their new hires are legally authorized to work in the United States. They do this by having the employee complete a Form I-9 and by examining documents that prove the employee's identity and work eligibility. Option B is incorrect because providing medical insurance is not a requirement under IRCA. Option C is incorrect because new hire reporting is for child support enforcement, not a requirement of DHS under IRCA. Option D is incorrect because IRCA does not require employers to hire a specific percentage of immigrant workers. 34. Which law requires federal contractors to take affirmative action to employ veterans? A. Americans with Disabilities Act. B. Vietnam-era Veterans Readjustment Assistance Act. C. Age Discrimination in Employment Act. D. Worker Adjustment and Retraining Notification Act. Can you guess the answer? Correct answer, B. Vietnam-era Veterans Readjustment Assistance Act. Explanation. Option B is correct because the Vietnam-era Veterans Readjustment Assistance Act requires companies with federal contracts to take affirmative action to recruit, hire, promote and retain veterans, especially those who served during the Vietnam era and other protected veterans. Option A is incorrect because the Americans with Disabilities Act prohibits discrimination based on disability. Option C is incorrect because the Age Discrimination in Employment Act protects individuals 40 or older from age-based employment discrimination. Option D is incorrect because the Worker Adjustment and Retraining Notification Act requires employers to provide advance notice of plant closings and mass layoffs. 35. Which of the following is prohibited by the Equal Pay Act? A. Paying men and women different wages for performing substantially equal work. B. Providing different benefits packages to executives and hourly workers. C. Paying bonuses based on seniority. D. Offering merit-based promotions. Can you guess the answer? Correct answer, A. Paying men and women different wages for performing substantially equal work. Explanation. Option A is correct, because the Equal Pay Act makes it illegal for employers to pay different wages to men and women for jobs requiring substantially equal skill, effort, and responsibility under similar working conditions. Option B is incorrect because providing different benefits, packages to different job categories is generally permissible. Option C is incorrect because paying bonuses based on seniority is a legal exception to equal pay requirements. Option D is incorrect because offering merit-based promotions is a legal practice and not prohibited by the Equal Pay Act. 36. Which legal doctrine allows employers to be held responsible for harm caused by their employees during the course of employment? A. At-will employment. B. Respondeat superior. C. Contributory negligence. D. Frolic and detour. Can you guess the answer? Correct answer, B. Respondeat superior. Explanation. Option B is correct because respondeat superior is a legal term that means let the master answer. In employment law, it says an employer can be held legally responsible for the wrongful or negligent actions of their employees, as long as those employees were acting within the scope of their employment when the harmful act happened. Option A is incorrect because at-will employment is about the ability to terminate employment, not employer liability for employee actions. Option C is incorrect because contributory negligence is a defence used in tort cases when the plaintiff's own negligence contributed to the harm they suffered. Option D is incorrect because frolic and detour is a concept that describes when an employee is not acting within the scope of employment, which would typically relieve the employer of liability. 37. What is the purpose of the National Labour Relations Act? A. To prohibit employers from hiring workers under the age of 18. B. To regulate overtime and minimum wage requirements. C. To protect workers' rights to form unions, collectively bargain and strike. D. To mandate the provision of health insurance by employers. Can you guess the answer? Correct answer, C. To protect workers' rights to form unions, collectively bargain and strike. Explanation. Option C is correct because the National Labour Relations Act, also known as the Wagner Act, protects the rights of most private sector employees to organise into labour unions, engage in collective bargaining with their employers, and take part in group activities like strikes to try and improve their working conditions. Option A is incorrect because child labour laws, which prohibit employers from hiring workers under the age of 18 in certain situations, are part of the Fair Labour Standards Act. Option B is incorrect because the Fair Labour Standards Act regulates overtime and minimum wage requirements. Option D is incorrect because laws like the Affordable Care Act regulate the provision of health insurance by employers. 38. Which of the following situations would likely violate the Fair Credit Reporting Act? A. An employer fails to inform a candidate that their credit report will be used in the hiring decision. B. An employer conducts a criminal background check on a new hire. C. An employer provides training to all employees. D. An employee disputes the accuracy of their paycheck. Can you guess the answer? Correct answer, A. An employer fails to inform a candidate that their credit report will be used in the hiring decision. Explanation. Option A is correct because the Fair Credit Reporting Act has rules about how employers can use consumer reports when making hiring decisions. One important rule is that if an employer plans to get a consumer report on a job applicant, they must first tell the applicant in writing that they are going to do so, and they must get the applicant's written permission. Failing to inform the candidate is a violation. Option B is incorrect because conducting a criminal background check is generally allowed if Fair Credit Reporting Act rules are followed, such as providing notice and obtaining consent. Option C is incorrect because an employer providing training to all employees is not related to the Fair Credit Reporting Act. Option D is incorrect because an employee disputing the accuracy of their paycheck is a labour dispute, not a Fair Credit Reporting Act violation. (39) What is an example of an illegal action under the Americans with Disabilities Act? A. Asking a candidate if they can perform the job's essential functions. B. Refusing to hire a qualified candidate because they have a disability. C. Offering a reasonable accommodation to an employee with a disability. D. Modifying work hours for an employee undergoing medical treatment. Do you know the answer? Correct answer. B. Refusing to hire a qualified candidate because they have a disability. Explanation. Option B is correct because the Americans with Disabilities Act makes it illegal for employers to discriminate against a qualified individual with a disability in any aspect of employment, including hiring. If a job candidate has a disability but is otherwise qualified to do the essential functions of the job, it is illegal to refuse to hire them simply because of their disability. Option A is incorrect because asking a candidate if they can perform the job's essential functions is a permissible question under the ADA. Employers are allowed to assess a candidate's ability to perform the required tasks. Option C is incorrect because offering a reasonable accommodation is generally a requirement under the ADA, not an illegal action. Employers are expected to provide accommodations to employees with disabilities to enable them to perform their job. Option D is incorrect because modifying work hours can be a form of reasonable accommodation, which is required by the ADA. This helps an employee manage their medical treatment while continuing to work. (40) Which of the following actions by an employer could result in a claim of disparate treatment? A. Failing to provide employees with adequate training. B. Hiring only men for management positions while equally qualified women are overlooked. C. Providing health insurance to employees. D. Offering performance bonuses to employees based on merit. Do you know the answer? Correct answer. B. Hiring only men for management positions while equally qualified women are overlooked. Explanation. Option B is correct because disparate treatment is a type of illegal employment discrimination where an employer intentionally treats an individual, employee or job applicant less favourably than others because of their race, colour, religion, sex, national origin, age or disability. If an employer consistently hires only men for management jobs and overlooks women who are just as qualified, that would be strong evidence of intentional disparate treatment based on gender. Option A is incorrect because failing to provide adequate training might be poor management, but not necessarily disparate treatment, unless training is denied based on a protected characteristic. Option C is incorrect because providing health insurance to employees is a generally legal practice if applied fairly to all employees. Option D is incorrect because offering performance bonuses to employees based on merit is generally a legal practice if applied fairly and without discrimination. 41. Which law protects whistleblowers who report fraud in companies that are publicly traded? A. Sarbanes-Oxley Act. B. Occupational Safety and Health Act. C. Immigration Reform and Control Act. D. Age Discrimination in Employment Act. Can you guess the answer? Correct answer, A. Sarbanes-Oxley Act. Explanation. Option A is correct because the Sarbanes-Oxley Act includes important protections for employees of publicly traded companies who report suspected fraud or violations of securities laws, making it illegal for employers to retaliate against these whistleblowers. Option B is incorrect because the Occupational Safety and Health Act protects whistleblowers for safety complaints, not necessarily fraud. Option C is incorrect because the Immigration Reform and Control Act deals with immigration issues, not fraud or whistleblower protection. Option D is incorrect because the Age Discrimination in Employment Act deals with age discrimination, not fraud or whistleblower protection. 42. An employee takes continuous leave under the Family Medical Leave Act. Which of the following is true upon their return to work? A. The employer must reinstate the employee to their previous position or an equivalent one. B. The employer can assign the employee to any available position. C. The employer must give the employee a promotion. D. The employer is not required to reinstate the employee. Do you know the answer? Correct answer, A. The employer must reinstate the employee to their previous position or an equivalent one. Explanation. Option A is correct because one of the key protections of the Family and Medical Leave Act is job protection. When an eligible employee returns from Family and Medical Leave Act leave, their employer must generally restore them to their original job or to an equivalent job that has the same pay, benefits, and other terms and conditions of employment. Option B is incorrect because the employer is legally obligated to return the employee to their previous role or one of equivalent standing, not just any available position. Option C is incorrect because the Family and Medical Leave Act does not mandate that employees returning from leave receive a promotion. Option D is incorrect because the Family and Medical Leave Act requires the employer to reinstate the employee to their former position or an equivalent one upon their return. 43. Which of the following actions is prohibited under Title VII of the Civil Rights Act? A. Refusing to hire someone because they are over the age of 40. B. Discriminating against employees based on religious beliefs. C. Offering flexible work schedules. D. Conducting a background check on a potential hire. Do you know the answer? Correct answer, B. Discriminating against employees based on religious beliefs. Explanation. Option B is correct because Title VII of the Civil Rights Act of 1964 is a major US federal law that makes it illegal for employers to discriminate against job applicants or employees in any aspect of employment because of their race, colour, religion, sex, or national origin. So discriminating against someone based on their religious beliefs is prohibited. Option A is incorrect because it is prohibited by the Age Discrimination in Employment Act. Option C is incorrect because it is a work practice, generally legal if applied non-discriminatorily. Option D is incorrect because it is a hiring practice, generally legal if done fairly and in compliance with laws. 44. An employer violates the Fair Labour Standards Act by doing which of the following? A. Offering flexible work hours. B. Paying non-exempt employees below the federal minimum wage. C. Promoting employees based on merit. D. Providing employees with paid vacation time. What do you think is the answer? Correct answer, D. Paying non-exempt employees below the federal minimum wage. Explanation. Option B is correct because the Fair Labour Standards Act is the US federal law that establishes the national minimum wage, rules for overtime pay, record-keeping requirements, and child labour standards. It is a violation of the Fair Labour Standards Act for a covered employer to pay their non-exempt employees an hourly wage that is less than the current federal minimum wage. Option A is incorrect because offering flexible work hours is generally a legal employment practice and not a violation of the Fair Labour Standards Act. Option C is incorrect because promoting employees based on merit is a generally legal employment practice and not a violation of the Fair Labour Standards Act. Option D is incorrect because providing employees with paid vacation time is a benefit and not typically mandated by the Fair Labour Standards Act. 45. Which law regulates how employers gather, process, and retain health information about employees? A. Family Medical Leave Act. B. Health Insurance Portability and Accountability Act. C. Fair Labour Standards Act. D. Title VII of the Civil Rights Act. Do you know the answer? Correct answer, B. Health Insurance Portability and Accountability Act. Explanation. Option B is correct because the Health Insurance Portability and Accountability Act includes privacy and security rules that set national standards for how covered entities must protect the confidentiality, integrity, and availability of individuals' identifiable health information. Option A is incorrect because the Family Medical Leave Act is about providing employees with unpaid job-protected leave for specified family and medical reasons. Option C is incorrect because the Fair Labour Standards Act deals with minimum wage, overtime pay, record-keeping, and child labour standards affecting full-time and part-time workers. Option D is incorrect because Title VII of the Civil Rights Act prohibits employment discrimination based on race, colour, religion, sex, and national origin. 46. An employee files a complaint of gender-based discrimination. The employer subsequently reduces the employee's hours. Which legal issue is most relevant in this case? A. Constructive discharge. B. Quid pro quo harassment. C. Retaliation. D. Libel. Can you guess the answer? Correct answer, C. Retaliation. Explanation. Option C is correct because retaliation occurs when an employer takes a negative action against an employee because that employee engaged in a legally protected activity, such as filing a complaint about gender discrimination. Reducing an employee's hours shortly after they file such a complaint could be seen as retaliation for making the complaint, which is illegal under laws like Title VII. Option A is incorrect because constructive discharge is when working conditions become so intolerable that an employee is forced to quit. Option B is incorrect because quid pro quo harassment is a situation where something is given or taken in exchange for sexual favours. Option D is incorrect because libel is written defamation. (47) An employee was wrongfully terminated and seeks back pay. What does back pay represent? A. Compensation for future wages the employee would have earned. B. Reimbursement for lost wages from the time of termination until reinstatement. C. Monetary punishment for the employer. D. A severance package negotiated upon termination. Do you know the answer? Correct answer. B. Reimbursement for lost wages from the time of termination until reinstatement. Explanation. Option B is correct because back pay is a legal remedy that is often awarded to an employee who has been found to have been wrongfully terminated. It's an amount of money intended to make the employee whole by compensating them for the wages, salary, and sometimes benefits that they lost from the date they were illegally fired up until the date of a court judgment or when they are offered reinstatement. Option A is incorrect because compensation for future wages is typically referred to as front pay, which aims to cover potential earnings after the judgment or settlement, not before. Option C is incorrect because monetary punishment for the employer is referred to as punitive damages, and these are awarded to punish the employer for egregious misconduct, not simply to compensate for lost wages. Option D is incorrect because a severance package is negotiated upon termination, often including pay and benefits, but it's agreed upon at the time of separation, not awarded retroactively due to wrongful termination. (48) Which of the following types of businesses is exempt from the Fair Labour Standards Act? A. Seasonal amusement businesses. B. Corporate law firms. C. Manufacturing companies. D. Retail stores. Can you guess the answer? Correct answer, A. Seasonal amusement businesses. Explanation. Option A is correct because the Fair Labour Standards Act, which sets rules for minimum wage and overtime, has some specific exemptions for certain types of businesses or employees. One of these exemptions is for certain seasonal amusement or recreational establishments, like some amusement parks, carnivals, or summer camps that only operate for a limited part of the year. Option B is incorrect because corporate law firms are generally covered by the Fair Labour Standards Act and must comply with its wage and hour provisions. Option C is incorrect because manufacturing companies are typically subject to the Fair Labour Standards Act and its requirements regarding minimum wage and overtime pay. Option D is incorrect because retail stores are generally covered by the Fair Labour Standards Act unless specific employee exemptions apply. 49. Which law prohibits employers from firing workers due to their association with a person of a specific national origin? A. Immigration Reform and Control Act. B. Title VII of the Civil Rights Act of 1964. C. Americans with Disabilities Act. D. Occupational Safety and Health Act. What do you think is the answer? Correct answer, B. Title VII of the Civil Rights Act of 1964. Explanation. Option B is correct because Title VII of the Civil Rights Act of 1964 makes it illegal for employers to discriminate against employees or job applicants based on their national origin, which includes protection against discrimination based on a person's association with someone of a particular national origin. Option A is incorrect because while the Immigration Reform and Control Act has anti-discrimination provisions related to citizenship and national origin, Title VII provides broader protection in this context. Option C is incorrect because the Americans with Disabilities Act focuses on preventing discrimination against individuals with disabilities, not national origin. Option D is incorrect because the Occupational Safety and Health Act is concerned with workplace safety and health standards, not discrimination based on national origin. (50) An employer fails to notify workers of a plant closing 45 days before the closure, violating federal law. Which law did the employer breach? A. Worker Adjustment and Retraining Notification Act. B. Fair Labour Standards Act. C. Occupational Safety and Health Act. D. Family Medical Leave Act. Can you guess the answer? Correct answer, A. Worker Adjustment and Retraining Notification Act. Explanation. Option A is correct because the Worker Adjustment and Retraining Notification Act is a US federal law that requires many larger employers to give their employees at least 60 days advance written notice before they have a big plant closing or a mass layoff. If an employer only gives 45 days notice, they are likely violating the WGU Act. Option B is incorrect because the Fair Labour Standards Act deals with minimum wage, overtime pay, record keeping, and child labour standards affecting full-time and part-time workers in the private sector and in federal, state, and local governments. Option C is incorrect because the Occupational Safety and Health Act aims to ensure safe and healthful working conditions for workers by setting and enforcing standards and by providing training, outreach, education, and assistance. Option D is incorrect because the Family Medical Leave Act entitles eligible employees of covered employers to take unpaid, job-protected leave for specified family and medical reasons with continuation of group health insurance coverage under the same terms and conditions as if the employee had not taken leave. You have reached the end of our first question set. For the free complete exam preparation, visit our website link in the description, where you find thousands more practice questions and comprehensive study guides. Thanks for studying with us today. See you in the next video.